Hi, everyone, and welcome to our first installment in our legal series with today's topic that we've called Employment Standards from Policy to Practice, where we'll be discussing some top issues from a duo of perspectives and joined as well by Yvonne here. My name is Liz Tang. I use the pronoun she, her, and I'm the program coordinator for IntegralOrg. It is important that we do acknowledge take time to recognize that what we call Alberta is the traditional and ancestral territory of many peoples, presently subject to Treaty 6, 7, and 8, namely the Blackfoot Confederacy, the Kainai, Piikani, Siksika, the Cree, Dene, Saulteaux, Nakota Sioux, Stoney Nakoda, and the Tsuut'ina Nation, and the Métis people of Alberta. This includes the Métis settlements and the 6 regions of the Métis Nation of Alberta within the historical Northwest Métis homeland. And we do respect the histories, languages, and cultures of First Nations, Métis, Inuit, and all of the First Peoples of Canada who have lived in and cared for these lands for generations. We're grateful for the traditional knowledge keepers and elders who are still with us today and those who have come before us. And we make this acknowledgement as an act of reconciliation and gratitude to those whose territory we reside and work on today. Very happy to introduce, and I will spotlight her. There we go. Our very own Yvonne Chenier, legal counsel for IntegralOrg, and our moderator for today. She's a lawyer and philanthropy consultant and a co-founder of IntegralOrg. Yvonne brings more than 35 years of experience helping those in the philanthropic, nonprofit, and social enterprise sectors as a general legal counsel and an advisor on planning, organizational, regulatory, and governance matters. Yvonne is an active member of the executive of the charities and nonprofit section of the Canadian Bar Association and is past chair of both the Alberta and national sections. And she's named in the Canadian Legal Lexpert Directory for excellence in charity law and has been selected by her peers for inclusion in the best lawyers in Canada for her work in charities and nonprofit law. And so with that, take it away, Yvonne.
Thanks very much, Liz. And with IntegralOrg, our mandate is education of charities and nonprofits and helping you all. And there's more to the legal requirements for charities and nonprofits than what actually is charity and nonprofit law. And we recognize that there are many other important issues that you face that create regulatory burdens for you, such as employment standards, human resources, etc. And that is why we are putting these kind of sessions on in our legal series at IntegralOrg. So we're very pleased to have 2 wonderful people to help today and speak on the topics that we've chose on employment standards and human resources. And I'm pleased to introduce them. Melissa Rico will speak first, and she became a member of the Law Society of Alberta a few years ago in 2004. She joined her current firm, Carbert Waite LLP, in 2006 and became a partner in 2017. She practices in all areas of civil and commercial litigation, but her primary practices are employment law and health law. She has extensive experience representing employers and employees on a wide variety of matters, including termination of employment, employment contracts, human rights, privacy, and disability issues. So with that, I'm going to ask Melissa to put up her slides, and she can run you through some of the very basic information that we wanted to impart to you today on employment standards.
Thanks, Yvonne. Can you all see my screen? I hope.
Looks good.
Excellent. Well, thanks, Yvonne, for the introduction, and Liz, and I'm really pleased to be here to be presenting with Kate. So my section of this presentation will be about 20 minutes, and I know we have some time for questions at the end, so keep the questions coming and we'll get to as many as we can. So with that, I've termed this Beyond the Basics and have tried to organize my presentation in terms of issues that I see as an employment lawyer. And as Yvonne said, I do both sides in terms of helping individual employees as well as advising employers. So these are some of the common employment issues and how to avoid them. Here's our roadmap for the next 20 minutes. I'm going to do a bit of a refresher about employment obligations and how do they arise and by what statute, or we'll go through that in quick. overview. Then we'll talk about the 6 common issues. And then there might be a little bit of time for some Q&A depending on where we are with time. So with that, what creates legal obligations for the employer? And the first is the statute. I'm sure you're all familiar with this, the Employment Standards Code, which is Alberta legislation. I don't think many of you are governed by the Canada Labour Code. So that would be if you're a federally regulated not-for-profit. So you're under one or the other. And then again, the Human Rights Act. I think you're all probably familiar with this as well, which will deal with protected grounds. And then the last piece of legislation is the OH&S, the Occupational Health and Safety Act. And Yvonne and I did a presentation, I want to say last fall, which was a bit more robust in terms of dealing with obligations that arise in the human rights and OH&S. And I think it might be taped. So if you're interested, I'm sure you can find it. The second area where they arise is common law. And I get this question like, what is common law from my clients? And that's really, what do the courts say? And the courthouse is very handily just across the road from us. And I point to that and say those green glass windows are where the justices pronounce on similar situations that you as an employer or as an employee will be dealing with. So for instance, severance, what's a reasonable severance obligation would be something that is regularly dealt with at the courts. And we can research to see what comparable cases will say. The last is contract, and we are going to spend a bit of time talking about contracts today. And that is what you have agreed upon with your employee. So what does it say? And then it's great if it says something, but the next question from a legal point of view is it enforceable? So you're only so good as the paper it's put on and how it was rolled out. And we'll talk a little bit about some of those issues. And again, also policies. So those are sort of the 3 things, the trifecta, that create obligations as an employer. What does not result in legal obligations? And I'll just touch on this pretty quickly. So government benefits, so CERB and EI, and then employee preferences. And this is quite different than requests for accommodation that are due to a protected ground under human rights legislation. So a person saying, I wish to work at home, which I'm sure many of you are dealing with, is not the same as I need to work at home because I have a disability that doesn't allow me to do X, right? So just wanted to touch on that as a quick overview before we launch into our issues. So issue 1, and Liz is going to launch a poll for us, is should I have an employment agreement? And my question is, do you have one? So I'm going to look at a different screen. That's where the poll is popping up, but please enter whether you have one or not. And then we'll move on. We'll give it about like 20 seconds.
I'm trying to get this poll up. Don't know if people can see it. I believe if the other admin is online, Jennifer, you might have to launch it because it's telling me there's 2 of us.
Too many cooks in the kitchen.
Yeah. You can see it?
But it says 0 have participated.
Oh, geez. Oh, it says we see the poll results. Oh man, these polls. It gives me, this is a screen I've never seen before in the polls. It just says I'm logged in from another device.
And that's okay. We can try. We have 2 polls. I don't want to miss out or waste time on that. But if I could see you, I hope most of you have your hands up to say, yes, I have an employment agreement. So we're going to go with that. And if you don't have one, I would say you should have one. And it is important because it is going to set out what is your relationship with your employee. So the next slide is really considerations, is what should your employment agreement include? And you'd be surprised at how many organizations I advise where 1, they don't have an employment agreement, or 2, it's not doing what it should. And these are just things you can consider. And the biggest one, I think, is the termination clause. And if there's a theme I'm going to use throughout the next 20 minutes, is sort of proactive risk management. And the reason why I say that is your agreement should be thinking proactively about what are my obligations to the employees and how can I protect the organization from future issues, such as severance. And I saw in our prep that there was a question about what reasonable severance is, which we'll touch on. But your termination clause can address that. So if you have an enforceable, well-crafted termination clause, which we'll talk about in the next issue, that can protect proactively your organization from large severance obligations. Other things I'll just touch on quickly. Do you have a confidentiality clause? That should be in there. Non-compete, non-solicitation is probably not as applicable to the not-for-profit sector, but it's something to give thought to. Bonuses, are you including bonuses? How are they calculated? When are they calculated? Does the person need to be actively employed to be qualified to get the bonus? How are you dealing with vacation? What about leaves? And then hours and shifts, which we'll talk about a bit when we talk about another issue, which is overtime. The key with employment agreements is to remember that you cannot contract out of the code. So I'm coming back to that foundational trifecta, the first one that says the Employment Standards Code governs. The minimum must be met, cannot contract out of the minimum, even if you have a well-crafted employment agreement. And I'd say if you are trying to contract out of the minimum, it isn't well-crafted. That's not a good agreement. So I'm going to move to the next slide, which is issue 2. And this is my termination clause enforceable? So we're narrowing down. We've talked about, great, I have an agreement. And as I said, the biggest issue for me that I see is, do I have a termination clause? And where it really arises is for long-term employees in high-level positions. And it is challenging to give advice to say, yeah, you're paying upwards of a year of total compensation. So that, I think, particularly in the not-for-profit sector, is a really big bonus and burden to put on them. So Liz, I don't know if we can try to launch this poll, or should we just move on to chatting about?
I think what's happened is the last person that logged onto our account has the ability to launch the polls, but I think we'll maybe try not to do it this time. But if you guys want to enter in the chat, if you're confident that your termination provision is valid, yes or no, we might get some sense of where we're at with that.
And don't be afraid to be like, I'm not sure, because that's why I have a job, right? And to be quite honest, I was in charge of dealing with our contracts last year and reviewed things, and I caught an error. So I had to deal with the same issues. Being an employment firm made me sort of chuckle. But, it is good to review. And I'll say, just as another point, review your contracts on a regular basis, probably every couple of years. You want to make sure that you're up to speed with what is required. So no right or wrong answer. Are you confident or not? Well, seek legal advice if you're not sure.
Yeah, it's looking like a split in the chat between yes and no, and we're somewhat not confident.
And to be fair, there were quite a few cases, and they're getting a little old because they were pre-COVID, which is what time went by in a blur, or it really went slow during the pandemic. But there was a flurry of cases, I want to say in 2018-19, that dealt with termination clauses and how do you make sure that they are indeed enforceable. But from a very basic, what we're looking at is, have you met the minimum? So coming back to the very first part of the trifecta of what creates employer obligations, are you meeting the minimum? And I looked, it is section 56, which says how much notice needs to be provided. That's termination notice under the code. Of course, that's not preventing you from being generous and offering more. And that's why I say, well, how is it calculated? Are you only going to give code, or are you going to give more than that? And is it going to be a formula of X number of weeks per year of service? Or will there be a base, like 2 weeks plus 1 week per year of completed service? Are you going to count partial years of service? How are you doing that? So the first part is sort of duration. And then the second part is, what are you using to calculate the compensation during that duration? So that's my question of, is bonus included? Or is it only your base salary? what other perquisites are included. So I'll share that typically my advice is do your formula however you wish it to. I rarely recommend that you give only the base, which is the code notice. But I will say, if you craft it carefully, you can limit it to only your base salary and not have the bonuses, which is particularly relevant when you have big parts of compensation coming from a bonus scheme. The release. So are you asking for a release? You cannot ask for a release if you're not giving more than the base, which means Employment Standards Code minimum, which is why I rarely say, don't just give the Employment Standards Code. You want the protection of the release at the end of the day. So even if it's saying this can be a catch-all general termination clause, you're entitled to whatever the applicable employment legislation is, plus 1 week. Not so generous, but it allows you to then say, in order to retain and keep the addition, whatever it might be, the 1 week over the code, you are required to return to us a release. So that's a way to be proactive about your risk management. The last thing is your termination clause should consider the notice or pay in lieu of notice, meaning can you just give a written notice and then have at your sole discretion as the employer to say, I'll pay you out. So moving on, reading the employment agreement as a whole, I'm not going to bore you with this case. It's Waxdale. It was a 2020 case out of Ontario. The key takeaways, read it if you're interested. The key takeaway is that you read your entire employment agreement as a whole. So one piece of your employment agreement is not good, meaning you have not provided the minimum in the code, your whole contract fails. This is no good. And this is actually where I reviewed our contracts with our associates and thought, oh gosh, we got to fix something. And I'll tell you what that is when we get to the next few issues. So the key is meet the minimums. Otherwise, your whole contract's going to fail, including your very carefully crafted termination provision. So if you did it properly, if you failed somewhere else, everything is gone. Kind of scary. Issue 3 is dealing with making changes. So what we're really talking about here is this concept of constructive dismissal, which alone could be like a 2-hour seminar. These are the trickiest cases. We see a lot of them. I always say constructive dismissals are really hard from both sides, as employee or as employer. But I've given you the definition here. So if you're trying to change something, you have to step back and say, is this the fundamental term that I'm unilaterally changing as the employer? And does my employee not agree to it? The most common one I see is my employers say, oh, I don't have a good termination provision. That's not good. Melissa, can you introduce a termination provision? And I say, yes, I can, but I have to do it in a way that makes it enforceable. So here are my practical considerations. So is it a fundamental change? Has my employee agreed? And this is where, if they haven't agreed, how do I do this and still make it legal? And the answer to this, again, is quite complicated, but it's essentially giving notice of it. So you would say, I'm going to be introducing this new contract that has a termination provision in 4 weeks, 8 weeks, whatever is appropriate. And how that is calculated as a very high level is based on what appropriate severance would be for that particular employee. So that's how we essentially try to mitigate proactively some risk management. A lot of information, I know, but feel free to reach out with questions for me. The fourth issue is, how do I terminate it? And there was a question in the preparation for this about probationary periods. So the probationary period is not dealt with directly in the Employment Standards Code, other than to say, pursuant to the code, you may terminate within the first 90 days of employment and not pay the termination pay under the code. Remember my trifecta, common law. It doesn't say that you won't necessarily pay common law notice, right? So the courts have actually said that it's disproportionate to the amount of time you work. So even if you work for 2 weeks, the severance that the courts will say you're entitled to common law may seem disproportionately big. So how do you deal with that? Have contracts, have good contracts in place that deal with termination during the probationary period that deal with both under the code as well as that common law. Performance improvement plans. So this one, I've never heard of this before, but quiet quitting. I just heard of this and I thought, oh, quiet quitting is sort of when you do the bare minimum and you're kind of skating along. This would probably be an appropriate PIP, performance improvement plan. My comments here are, do the performance improvement plan early, be clear, have discussions with the employee about what you expect them to be able to do and when and how are you going to evaluate it. Keep in mind the goal to a PIP is to actually keep the employee. So if you're embarking on a PIP, you don't really want that person there, it's probably best to cut ties early. My last comment on here is cause and without cause terminations. And I'm sure you're familiar, but cause is tricky and is the onus for the employer to be able to establish. And the same thing, if there's a problem employee who's just kind of skating along, maybe it's time just to pull the trigger on your really crafted, well-crafted termination clause in your enforceable contract. And because you've limited risk in advance, you're not going to be open to a large figure. My one last thing on this, and I am mindful of time that I have 3 minutes left, but the one thing in your contracts and probationary periods must be 90 days. It is not 3 months. This was my mistake in our contracts. It used to say 3 months. 3 months is actually less than 90 days if you include February. You would be offside code, your whole contract will fail. That is a scary thing. So even if your termination provision is great, if your probationary period only says 3 months, then you need to redo your contracts, which I did. Issue 5, how do I limit overtime? And I apologize for going through this so quickly. Threshold questions are they actually entitled to overtime? Manager employees are not, certain professions are not. No surprise, we lawyers, we're not entitled to overtime. Overtime agreements. So you can have these agreements with your employees that will allow for banking. And then averaging agreements. And I know there is a specific question about this, is how do you do this? There were new rules rolled out for the Employment Standards Code in 2020 that allow for you to roll these out without employee consent. I've included a link there to alberta.ca that has a couple of sample agreements, which I thought were pretty good. As a quick averaging agreements, they're reported for shift workers, right? So if they're working 10 hours per day and maybe 12 hours per day over 3, we're going to be seeing overtime if you don't have an averaging agreement, because it's anything over 8 per day or 44 per week. The averaging agreement is really doesn't eliminate the obligation to pay, but will limit it. So think of it in the fact that you can't go over 44 per week. That will still maintain. You have to pay overtime at 1.5 if you're over 44. But because you're working the shifts, you're going to average that. So you're not going to pay the daily overtime. And that's, again, proactive risk management to not be paying large overtime amounts. The other thing is to have some policies around how do you get overtime. You need pre-approval in advance. We do that here. So if you need to do overtime, I want to know why, and I need the manager or someone to sign off on the overtime. My last issue, and I'm right at my time limit, is can the employee refuse to come to work? We're touching on OH&S, and I have to be pretty high level on this, but again, I think COVID times, people are starting to come back. You don't want to put your employees in danger. Certain people have a lower threshold for what they consider risk. So keep in mind that you have obligations under OH&S and the duty to do an investigation if there is that danger. And then remember, there's a lot of documentation involved with respect to the OH&S, and OH&S has some pretty hefty fines there, so you don't want to have to deal with that. So make sure you're complying with OH&S legislation. So with that, I'm right on time. I do not think we have time for Q&A until the very end after Kate's, but thank you. And I hope that answered some of the questions and you will give rise to some good conversation after.
Thanks, Melissa. Yes, and there have been some great questions in the chat. And I think after Kate's presentation, I'll curate some of your questions, rephrase them maybe a little bit so we can get the very best discussion going that will benefit most of you. So there's a lot to learn in the law, but there's a lot to learn in human resources generally, of course, for nonprofit organizations and charities. So Kate Ashton will speak a little bit about the human resource issues involved in our presentation today. And Kate is a chartered professional in human resources. She's got more than 15 years functioning as a senior HR professional within organizations across many different industries. And as a strategic partner, she provides guidance and support, advising business leaders on optimizing the workplace experience and becoming an employer of choice, which I know we all want to be. So without further ado, I know Kate has her own good slides, and I'll turn it over to Kate.
Great, thanks, Yvonne. Just share my screen here. Okay, hopefully everyone can see that. So, my presentation today is to really take some of the foundational pieces that Melissa had touched on from the employment standards law perspective and talk about, I think, some areas, some common pitfalls of where the practical application and navigating these legislative requirements can be a challenge for employers. So this afternoon, we're going to be speaking about some examples of areas for common pitfalls when employers are navigating actually applying employment standards. So today we're going to include talking a little bit more about overtime exemption, hours of work, statutory holiday pay, out-of-province employees, probationary periods, termination pay. Then we'll also touch a little bit on volunteers, and then wrap up the session this afternoon by talking a little bit more about attraction and retention for employees and volunteers. I know pretty much all sectors are experiencing challenges with, Melissa touched on it, that quiet quitting, and also the ability to retain, but also attract strong talent when it comes to employees and also for volunteers. And then if we have time at the end, we'll wrap up with any remaining questions. So starting out, so common pitfalls when we're looking at navigating employment standards. So starting with overtime, so Melissa talked a little bit about the averaging agreements. However, it's important to understand who is actually eligible for overtime so that when you're looking at trying to manage expectations and schedules, that you understand there are certain roles and professions that are not eligible for overtime. So under the Act, it does indicate that managers, supervisors, and those employed in a confidential capacity are not eligible, and also professionals such as chartered accountants and IT professionals. There's actually a longer list on the Employment Standards website that I encourage you to take a look at to truly understand what roles within your organization may fall under that ineligible or eligible category. When you are determining whether a role may be ineligible, one thing to keep in mind is just because a title says supervisor, for example, if the role really does not meet the threshold of what employment standards would be looking for, it may not qualify. So it's important to really consider and reach out to the appropriate resources to determine it. And an example of where a supervisor may not qualify to be ineligible is because the role might have the title of supervisor, but their responsibilities and their position within the organization really don't justify the role to be exempt. So for example, it's a supervisor title, but a very junior role, and the individual may not actually have any direct reports. So that's an example of where a supervisor may actually be entitled to overtime and not exempt under the Act. So it's important to understand the details and the nuances when you would be trying to make that determination. In the hours of work aspect of employment standards, I think many of us understand and know that if we are scheduling employees for shifts that may be under a 3-hour minimum, that we are required to pay that minimum wage equal to 3 hours for calling an employee in for a shift. However, now with, I think, the volume of people who are working remotely and working from home for their work, if the employee is not required to be called on site in order to conduct the work or attend a meeting, the 3-hour rule does not apply. So for example, if you had a team meeting, the entire team was joining the mandatory meeting virtually, and it was just a 45-minute meeting, you would just be required to pay for the time in which they were working, so attending the meeting or conducting work for the organization. So statutory holiday pay, I think it's really important to ensure that you, as an organization, you're checking your policies and your practices to ensure that you know what holidays actually qualify for statutory holiday pay under employment standards. So on the employment standards website, there is an outline of specifically what holidays in Alberta qualify as statutory holiday. And some of the common holidays that we may receive in an organization aren't necessarily statutory. So an example of this is the August civic holiday. In Alberta, it is not considered statutory. It's usually an optional holiday that employers may give. And so there becomes maybe a misunderstanding that it's actually a statutory holiday where overtime would be required. And then also the new federal holiday of September 30th for the Day for Truth and Reconciliation. Alberta has not added this as a statutory holiday, and so therefore there would not be overtime implications. It is so important, though, with any of these aspects that they're supported by clear and consistent policies that can support managers in enforcing these details. So another consideration is out-of-province employees. So with many employees working remotely, there's been organizations that have experienced what was an Alberta-based employee moving out of province and working permanently from another area of Canada. This is important to understand the implications that the individual, by residing permanently in another province, a different provincial legislation most often will apply to them. There is some recent language added to employment standards for Alberta that does open a small window of possibly being able to enforce Alberta legislation on an employee outside of the province. However, it's important to ensure that you get appropriate consultation to ensure that you are able to add this caveat and that it's supported, again, with clear documentation and contracts. Talking a little bit about the 90-day probationary period, further to what Melissa was touching on, the 90-day probationary period under employment standards is that time frame in which under the Act you can terminate an employee without the obligation of termination pay in lieu of notice. However, a lot of questions that we get from our clients is, what if the employee has changed a position and we've extended the probationary period as part of the trial for this new role? In a situation like that, again, keeping in context to what Melissa had touched on, as far as you cannot write into contract anything that does not meet the minimum standards for the employment legislation, is that if you did end up terminating an individual, that you extended their probationary period beyond 90 days, you would still be required to pay the minimum entitlements under Employment Standards Act. Even though you may have indicated that their probationary period was extended to review their abilities to perform in the role. Another item on 90-day probationary period is, a lot of times those 90 days sneak up. And so an employer is all of a sudden scrambling at the last moment, realizing that an individual that has been underperforming is now reaching or exceeding the 90-day period. So it's important that throughout those first 90 days of employment, that there is, consistent review and conversation with new employees to understand how they're performing in the role, answering questions, and closing any training or learning gaps. And that if there is a decision or there's concerns early on in the relationship that the individual is not a fit for the role, that decisions around terminations are made in advance of that 90 days, because once you hit and exceed that, you now have additional implications from termination pay. And then talking about termination pay, so we have the minimum standards under the Employment Standards Code, which is the pay in lieu of notice, which is tied to the length of service. And then, as Melissa also spoke to, common law entitlements kick in, and it is more of a gray area of what would the courts award given the circumstances of the termination. And there's a lot of factors that go into what would that common law entitlement look like. And it includes the length of service, the seniority of the role, the ability for the employee to find comparable employment in the current circumstances. So if the economy is in a slump, there is a flood of talent in the marketplace, the individual is entering the marketplace at an older age with a lack of training or education, then that could add to higher common law entitlements. So it's important to get appropriate consultation and guidance when you are determining what common law might need to look like on an individual basis for an employee. It's also important to ensure that you've checked their employment agreement to confirm that there isn't something specifically outlined for a termination clause on what they would be entitled to, or if a collective agreement was in place. It's always important to check the alberta.ca website to ensure that you have correct and up-to-date information. So then just touching on volunteers. So it's important to set them up for success just like you would with a new employee. Give them clear expectations and a clear understanding of their responsibilities. Volunteers do fall under the worker classification under the occupational health and safety legislation. So for example, they are included with details for workplace harassment and violence prevention policies and plans. So volunteer responsibilities, at minimum, nonprofit organizations should provide its employees with scope of duties to explain their specific tasks, including a description of the work and the duties they'll perform, any authorizations, licenses, training, or requirements for that work to be completed, where, when, how, and with whom the work will happen, what will be out of scope for their role and duties, the appropriate orientation and training needed to perform their duties, an awareness of any insurance coverage that may apply to their role, an awareness of any potential liability, risks, and how to mitigate them, a review of hazard assessments and OHS information, and information of company policies that relate to their role. So then moving to the last section here, keeping an eye on time, attraction and retention for employees and volunteers. So I think all organizations are facing a challenge to actually attract both volunteers and qualified talent for the organization. And so there's a few things to keep in mind as you look for ways to continue to attract top talent and attention from volunteers who want to partner with your organization, but also once you have them, how to retain them, how to keep them engaged. So workers today often will make a decision to stay with an organization if they're aligned with the vision, see purpose in the work they do, are provided an opportunity to give back to the community, have flexibility to do their work and volunteer duties. Part of this includes defining your employment brand. So what does the organization stand for? What are the organization's core values? How do you live them? And how do you embed them into the organizational culture? Then ensure to align them with your employment or volunteer offering. So compensation is always a factor when we're looking at attraction and retention. However, it's only one factor amongst many others that are important to employees when they're making a decision or volunteers in what organization to partner with. So nonprofits can look at cost-effective ways to offer perks and benefits that go beyond legislative minimums to attract and retain employees and volunteers. So look at ways that you can increase your value proposition, your total rewards offering to your employee group that may not be as explicitly tying a cost to the organization. So some ways can be increasing vacation entitlements, which absolutely have a cost, but they're often an easier way to add in additional perks and benefits when salaries might be a limited capacity to increase. Other benefits like wellness programs, paid days off, and also team building and company events. And then it's also important for the nonprofit sector to look outside the sector for talent with transferable skills. So someone that might come from the private sector that would be interested in joining our organization because they're passionate about the cause. And they would have transferable skills from outside the sector to be able to come in, and there may be sector-specific training that's required. However, they would be able to be a valuable contribution to the team. So with any of these pieces, it's always important that you ensure clear and consistent communication with employees and volunteers, including positive feedback and constructive feedback. It's ensure that all of this is supported by clear and consistent policies and practices for all workers. I think that when we're looking at engagement and retention, ensuring that expectations of the volunteer and the employee at the time that they were being brought on or making a decision about joining the organization, that their experience once they've gotten into the organization is consistent with what was described and promised to them. I think what we often see with turnover of new employees is that what the experience they were made to believe they would have with your organization, once they get inside, they realize it's actually not the reality of what is practiced every day. So just ensuring that the vision, the mission, the values that the organization promotes, that you can fulfill those and promote them internally with your culture as well. So these are just some of the resources. It's important that you do reference the Employment Standards website on alberta.ca. The overtime pay specific link is here, and then also ensuring that you're accessing the Occupational Health and Safety website for reference also. And there's also some great tools and toolkits available on their website as well. So that's the end of my presentation. I think I might have a couple of minutes for questions, or Yvonne may want to just open it up to the larger team for questions. Please feel free to connect with us online, and I'll pass it over to Yvonne.
Thank you, Kate. That was very good practical tips. And I appreciate the fact that you tied in volunteers in the presentation, even though they're not covered under the Employment Standards Act. As you pointed out, they're covered under the Occupational Health and Safety Act. And for the nonprofit organizations, they're a valuable part of the team and should be looked after properly. And that would include a lot of the kind of policy work you're talking about. So we have a lot of questions, and I'm so happy both of our excellent speakers kept their time, and now we've got some good questions. So I'm going to start with Melissa. As usual, lots of legal questions pop up in people's minds as we're going through this, and I've curated them a little bit. And one good question that I think comes up a lot is some organizations have employee handbooks that have a lot of information in them. If the termination provisions and all other good employment things are contained in the handbook, do you have to have those provisions also in the employment contract, or can you just somehow tie in to the policy from the handbook?
So I've seen this quite often where there's a lovely long employee handbook that contains particularly the termination provision. And I would say it should be in the employment agreement, not in the policy handbook, even if you have a disclaimer at the bottom of your employment agreement that says, I, employee, have read and agreed to all of the employee policy handbook. I think that's better. But the fact is, the courts have said, has that termination provision, which is drastically reducing their common law entitlements, been brought to the employee's attention when they signed? And it is far better for the employer to say it was in the actual employment agreement, not buried in a big handbook that talks about benefits and other things. While important, are not as restrictive of the common law rights. So I would say put it in the employment agreement.
Good, a good cautionary note there. Another question highlights some of the jurisdictional issues lawyers have to deal with when we're talking to clients too. One participant said that she was told the term severance pay is a legal term, only mainly used in Ontario. And Alberta has termination notice, pay in lieu of notice in our act. can you talk a little bit about the differences in provinces of employment standards, and if indeed this kind of terminology causes confusion, Melissa?
Yes, and you're right. It is actually, I believe, severance is a defined term in the Ontario employment legislation. And that person is correct. It is termination pay or pay in lieu of notice of termination. And I said that wrong. It's just pay in lieu of notice. But to me, we're talking about one and the same thing, really. So if you're talking about termination pay, we're inside of what the minimum is for the code. I'd say severance would be more commonly thought of as what the common law notice period would be when we are looking at cases that are coming out of the courts. So when I'm talking to my employee clients, severance is just the word on the street, right? So when I'm defining it in a contract, I'm a bit more specific. I use every single synonym known to man, so my employee is not confused. So I will say termination pay, pay in lieu of notice, severance, I'm trying to encapsulate it. So again, gold standard is really to try to make it crystal clear that if I'm limiting your entitlement when we're terminating your employment to something less than what common law would be, that there's no confusion about it.
Good, thank you. The next question, I think both Melissa and Kate could ring in on, because it sort of talks a little bit about the relationship between the Employment Standards Act, the law, and policies that the employee could be subject to that the employer creates. What if an employee fails to ask for overtime that they're entitled to? Can the employer refuse to honor those hours? So, one's a legal question, but to Kate, is there a way to put this kind of information in policy so everybody knows that they would be getting overtime, whether or not they ask for it in certain circumstances? So, Melissa, what would the law say? And Kate, what kind of policies would deal with this?
So Melissa, I can let you speak first to speak to the legal piece.
Well, the legal piece is no, you still have an obligation, so long as it's within the 2-year framework. Again, funny, not so funny, but we've had that arise where we did not pay properly. So we're still going to be on the hook so long as it's there's a 2-year limitation period within which to bring a claim about something you knew or ought to have known. So that's sort of a legal piece to it.
Yeah, and I think that's why it's also really important to support this with clear and consistently applied policy. So ensuring that it outlines that any overtime must be approved in advance, that there is a timeline to bring that forward if for any reason it was worked and not approved in advance, and guidelines to ensure that employees understand when it would be appropriate. I think clear and well laid out policy is the important part to support the employer in navigating when you may get an employee that all of a sudden brings you a spreadsheet full of extra time that they've put in, and for you to be able to work through to be able to have a case to say why it would not qualify. And that's where the importance of outlining within a policy what would qualify as required overtime or time that is payable as overtime to support the organization.
Thank you. And one other little segue question on that overtime. Can overtime agreement, can it be part of an employee agreement, employment agreement, or does it need to be separate?
Kate, do you want to weigh in on that?
Well, it's interesting to get your perspective, Melissa, from the enforceability. I would say my initial thought is that probably language in a contract to indicate that there's a clear guideline around overtime. And then if there are averaging agreements and policies in place that support that those are outside of it, because if there are updates to a policy and it was written in detail into the contract, you can run into issues later on with the fact that the contract and the policy could be different. Melissa, feel free to add sort of from your perspective.
Yeah, so from my perspective, I mean, it's covered in Section 23 of the Employment Standards Code is what is an overtime agreement and what needs to be in it. So to me, it's more about, it can be part of your employment agreement if you're including it and being clear. So to me, any agreement is only so good as each side knows what the obligations are vis-a-vis each other. So I don't really see a problem in building it into it, because I think if you're going to make changes to it, you're likely going to need a new agreement. So my instinct is to separate them, because if we're dealing with a new, it's going to get bulky. I think just from a practical perspective, it'll get long. And if you screw something up in your employment agreement that's not dealing with your overtime, then we'll have to fix things. There's more things to screw up. And I say that very casual language there, but I think if you tackle them as discrete pieces, it's more likely that you're going to get the components correct. But I don't really see a problem with having it as one in total.
Thank you. And then maybe the last bunch of questions all relates to the probation period, which leads me to believe maybe people are hiring people for 90 days or less and rotating them, or they can't keep people for more than 90 days, but we're getting lots of questions on probation. So maybe I'll just read a few of the issues that are coming out. Melissa, if you could just, capsulize the probation periods in the Act. And then Kate, if you could comment on the need for a robust policy so everyone understands what they're doing in this probation period and what rights are. So things like would everything else in an employee probation period, like benefits, etc., come into play as well? The 90-day period, do they have to pay benefits during that whole time as well? How do you calculate it? Do work days count? Is it calendar days? Is it longer than the 90 days in some situations? Part-time, hourly worker, those kinds of workers, does that make a difference? And can an employer extend a probationary period? So those are some of the questions that are coming up, and these I think are the key questions here to answer. But general comment on the probation law, period law, and the policy needs. So Melissa, why don't you go ahead and talk concisely about the law again?
I did read some of the questions going through. So the 90 days, I believe, is just 90 days. And I was actually doing a bit of research to see, because of course there's many pieces of legislation. The Interpretation Act actually deals with days and what the definition of is that. So my understanding, and I will double check this, I do not want to lead people straight, but I believe it includes weekdays and weekends. So it would just be 90 days. In terms of, is it part-time or not? If they work part-time, it's still going to be the 90 days, right? So from start to finish. I think it says not less than 90 days. That's when the trigger is that you'd have to pay termination pay. So the question about, can you extend the probationary period? The answer to that is yes. And I'm going to give a practical as to the only benefit to the probation period that I see as a lawyer is that you do not need to pay termination pay under the Employment Standards Code. And if you've done it properly in terms of saying not only that, but in the contract, you say you're not going to get common law notice or severance, whatever word you want to attach to that, then you're essentially locking it down to say you're not getting anything. So to extend it past that, you have to keep in mind that you're past 90 days now. So you will have obligations that will arise pursuant to the Employment Standards Code for termination pay. So to me, it's a bit of this, again, a misuse of the word probation per se, in terms of, well, it allows you in the 90 days to not pay termination pay. Thereafter, you're going to have some obligations that you'll have to deal with contractually.
Kate.
Yeah, and I think just to add to that, essentially the 90 days is black and white as far as beyond the 90 days, termination pay is required. So if you've extended the 90-day or the term probationary period beyond 90 days to continue to assess the person's fit and performance in the role, then you can continue to do that so the employee understands they're still being assessed. However, you would still have the termination pay in lieu of notice obligations that have come into effect beyond 90 days. So it's sort of what are you extending and what is your desired outcome by extending the probationary period. If it's so that the employee understands they're still being evaluated in the role, it's important that they understand that there still could be a termination after. However, they would now be entitled to termination pay based on their length of service. And then just to answer one of the questions, I think, about benefits entitled within the 90 days. So there's no requirement to offer benefits within that 90 days. That would be a policy, an internal organizational policy, and appropriate guidelines within your individual benefits plan with your provider. And so that, again, is where it should be important that it is outlined clearly in the employment contract and within your policies for your benefits plan, is when is the employee entitled to it.
I saw a question from another Melissa pop up about the executive. I said, my snafu, if your contract reads 3 months, do you change all employment agreements or you just change the new employment agreements? Yeah, that's how I came across it, where we were doing a new associate contract. And I saw, oh no, 3 months. We redid all of them. Because as I said, that is fatal to your contract. And you do not want to have spent all this time doing a great contract that has a perfect termination clause only to have it fail because you've said 3 months, not 90 days.
So, Melissa, my question to you is, did you redo the contracts that had already been signed?
Everybody.
And everyone had to re-sign. So, yeah. Right? Okay.
And then, again, it's a process. This is actually one of the biggest thing I do with employer clients is long-term employees require a lot of notice if they do not consent to the change, right? This one is not as big. From 3 months to 90 days, most people are past the actual time frame anyways, but we did it out of an abundance of caution because we don't want to put all this work in. And then remember, my theme of this is proactive risk management. We've had people with us forever and we are really proud of that. But if for some reason we wanted to end that relationship, we don't want to be on the hook for a massive pay in lieu of notice.
So Melissa,
go ahead.
So in a situation like that, let's say you've got 40 employees that have existing contracts. If that was the only piece of it that you were adjusting, could you look at the longest tenure of service? So let's say it's 10 years. You would take so that's 8 weeks advance notice of the change and just let the employees know, by December, we will be updating our employment agreements to just include revised language and just share it with them, but you're giving them sort of that advance notice that it's coming.
Yes and no. So yes, that's how I would approach to say pick the longest one because you're going to cover off the ones who are shorter tenure, but it's not just based on what common law says in terms of the notice period. So we're actually looking wider to the common law notice period, which, as you can imagine, can be very long, right? So when we're looking at employees that are, 15, I'm 17 years at my firm now, but I've kind of moved because I'm not an employee. But if you have long-term service employees who are in senior roles, then we're looking at potentially a notice period of a change in the contract of a year, right? So sometimes we have a rollout. But really our goal is to get acquiescence, or sometimes we do a weird hybrid of we'll pay you something, like some sort of form of consideration in addition to notice. So all really interesting and complicated ways to roll them out. And that is something that I continually counsel my employer clients on.
Thank you, Kate. Thank you, Melissa, for that final question, which really illustrates that there's a lot of pitfalls in this area, and it is best to reach out and get proper advice and information before you make any decisions. So with that, we'll terminate, and Liz will put up some more slides, termination of the program, but I would like to personally thank Kate and Melissa for the excellent information they've put down on this webinar today. So much information in an hour. Thank you very much. Liz?
Yeah, thank you. Yeah, we fit in a lot of answers to questions, so I'm really quite excited about that. Let me just go here. Sometimes there are questions that arise that need more in-depth information about your organization before we can offer a fulsome answer. And in these cases, we might suggest you partake in one of our free consultations, which look like short over the phone conversations or clinics, which are 1 hour problem solving sessions, often between Yvonne and other folks who are well versed in the nonprofit world. And you can find out more about these consultations by visiting our website or contacting our main number. And I see I already dropped the link in the chat, but we are very interested in getting a sense of what other topics, especially legal topics, that you'd like to explore. And so you can give your input on that evaluation survey link that I just popped into the chat. And otherwise, if your organization needs any more in-depth help, feel free to reach out to our admin, email, our phone number, or you could email me as well. And yeah, we'll just thank you all for joining us and all for the engagement, and we hope to see you all soon.